Well, I'd like to unpackage that statement that she just made. I'm in a good mood and not influenced by steroids. And that was a statement by the defendant. I'd like to introduce our special guest who's here with us to help analyze as a law and crime analyst. This is Brian Buckmire, public defender here in New York. Thank you for joining us today.
Thank you for having me here.
So listening at this point to the testimony about what he's saying, and he's saying you can record it, but I just want to get away from the work conversations and we can meet, somewhere other than the office. Is he a desperate wannabe have a friend, or is he a criminal?
I think that's where the distinction definitely comes here. When I first started reading the information and going into the documents that the witness is going through, the first thing that came to mind is like every stalker, because that's the charge he's charged with, is definitely creepy, but not every creepy person is a stalker. And he kind of toes this line where it's the language he's using is someone professional and he's trying to be amicable and trying to create a good work environment, but every once in a while he gets into that area where it's like, I don't know, that's kind of far, kind of weird, but I'm not sure if it's stalkerish.
So he could just be an individual that has some bizarre behaviors and tendencies. And I felt like with this particular correspondence, he's basically begging for a friend and begging for her to keep talking to him about personal stuff, and very socially awkward.
Correct. And I think this depends on what angle you're going at it, if you're a defense attorney or a prosecutor. If you're going for a defense attorney, I think you want to start cherry-picking your jurors to try to avoid, like, I'm a millennial. So maybe avoid millennials because we might have a little different definition of what's creepy and what's not. Maybe go to slightly older people who are a different generation, maybe more men than women, because this is really about an interaction between a man and a woman, and some people are going to have different interpretations of what emotional distress is.
All right, and let's see, does she testify about anything that seems that it's escalating behaviors? Let's return to her testimony. Mandy Bartelt now says he's taken it to another level because he actually located my mother and sent her a letter. Brian, thanks again for joining us. Do you agree? Has he now taken it to another level by locating her mother and sending an actual letter to her?
I think most reasonable people would think that's a line that goes beyond most normal cultures and most offices and most interactions with people. Going to someone's immediate family is very peculiar and very strange, unless there's some sort of relationship with the mother and Kachinsky outside of that. For example, maybe she came to an office party and they met, but like this is very, very peculiar.
So the next question is, does that amount to serious emotional distress of Mandy, which is one of the requirements under the law?
Correct. I think that becomes an argument as to her work afterwards. It's my understanding that this has occurred for longer than a year. So the instances, I believe, go from 2017 to 2018. She's still working there. So I think for the defense attorney, the argument as to that key element is, well, you're still employed. You're still working there. You're still able to do your Job. Judge Kachinsky is saying that your work is impeccable. So the emotional distress that is required for this charge does not seem to be present as per your work abilities.
Are we going to see more emotional distress as she continues to testify? You'll have to stay tuned. We'll be right back after this short break. Continues to push the boundaries and say, I don't care, I still want to have contact with you. So I want to talk now with public defender in New York, Brian, and ask you, how would you use the statute in this case to come up with or argue a defense to protect the defendant in this case?
So there's a number of ways that I would use the statute, specifically, as you alluded to, the serious emotional distress, and I would definitely highlight the seriousness of it, as well as the first portion which says intentional. Now, I'm not fully sure, and I'm sure plenty of Wisconsin lawyers are jumping up and down when I'm saying this, whether or not the intention applies to the actual course of conduct or the emotional distress that comes from it. What I mean by that is, in a lot of the emails, you can see him saying, I know that I'm communicating with you and I know that this might cause stress, but that is not my intention for you to have stress. So you can see that he is intentionally sending emails, intentionally communicating with her, but his intent is not to cause that serious emotional distress, and I would argue to a jury, therefore he cannot be guilty of this. I would allude to the idea of, I would especially talk to a little sexist, I talk to the men in the group and I say, imagine if you just wanted to buy a woman a drink at a bar, and you going up and saying, hello ma'am, may I buy you a drink? That caused her to have emotional distress because maybe the last man who bought her a drink completely destroyed her life. Now, was it your intent to cause that? No, but this statute might bump heads into that act. And I think going back to what I talked about picking the right jury, having that in their mind might move them in the direction that you want. The other aspect I would go based on what she just testified, the words that I got when she talked about leaning over or the continued acts was astounded, couldn't believe, shocked. But I didn't hear any words about serious emotional distress. I heard that she was like flabbergasted, taken off guard, but there wasn't that emotional distress that I would argue as a defense attorney would rise to the level of either harassment or stalking.
All right, so great creative criminal defense, and that's why you want a good defense attorney to represent you if you are facing any charges like this. Just a reminder, he has not been charged with any type of sexual harassment, but instead harassment. The other reminder is that trial is live today. We don't currently have a crew in the courtroom to show us that trial live, but certainly we will do that as soon as we can on Law and Crime, and then we will then talk about what all has transpired in the time that we've missed live. So we're going to take a very quick break, and then we'll return to see more of her testimony and see, are the behaviors continuing to escalate at this point or not? Well, we have gone from a witness saying there were some behaviors that we could interpret as bizarre to statements made by the defendant to the victim, including there's going to be fire and fury in the municipal building, and you'd better be psychologically prepared. Brian Buckmire, please tell me, does this take this to the next level from bizarre behavior to a crime?
I believe so. And I think any defense attorney, when they get that information, whether it be through discovery or if hopefully they're not hearing it for the first time, and hearing, their palm's going to be right in their head, and they're going to be shaking their head thinking, what am I going to do with this? The psychological readiness, the fire and fury, and even his explanation as to the fire and fury doesn't really hold muster. I believe he said it's something that he heard President Trump say, but he didn't mean it in the same meaning. It brings it not only past the serious emotional distress, but it brings them to the realm of potential harm to the complainant on the stand or their family member, because now the family member is being looked up, they're getting information sent to them, and now a reasonable person can infer that their family member might not be safe because now he knows where they live.
Could it not be also additional charges for making the statement there'll be fire and fury in the municipal building? I mean, this day and age, you can't play with those kind of statements. Judges can carry, at least in Georgia. Now, I don't know about in Wisconsin, but who's to say he could have had a gun, he could have had a bomb? I mean, is that a statement that could have resulted in even bigger, different charges?
It could have. So interestingly enough, I believe that New York actually fashioned some of its terrorist statutes after Wisconsin. I don't know how Wisconsin got ahead of the game in that one. But I understand what you're saying, that it could come close to a terroristic threat, but I don't think it goes quite there. For example, if I said, give me your pen or I'll hit you, that's definitely a threat. But it doesn't come to terrorism because I'm not threatening you to commit or to stop some sort of administrative act or some sort of governmental act. If I said in your capacity as a judge, make this ruling X, Y, or Z way, or I'll throw a pen at you, that, as facetious as it might sound, might be a terroristic threat, because now I'm asking you to change some sort of policy, change some sort of governmental action with the threat of force.
Okay, I mean, this is a fascinating trial to me. So as a judge watching this, hearing this testimony, looking at the statute, I think there's a lot to be argued and a lot of issues that this jury is going to have to look at and face and decide. So is there anything else that you've noticed in this testimony that you either find compelling or that makes you say, this is just kind of a weird guy?
So I'll do like most lawyers do, and I'll talk out of both sides of my mouth. As a prosecutor, I think what's very compelling is just the absurdity and the peculiarness of this man's actions. And he just keeps going and going and going. And when you think of a stalker, they keep going and going and going. So as a prosecutor, I think that's compelling there. As a defense attorney, I think the words in which she's using, the actions are peculiar. She might be breaking down on the stand here, but I would still go back to, she's still working there. She's still doing a good job as per all of her assessments. I would probably have someone on the stand from that office to kind of describe the office environment. Maybe it's completely different than the places that you and I work, but maybe in this office, and I've lived in Wisconsin for a period of time, having your professional and your personal life overlap is sometimes not that strange in southern cultures or the Midwest. So maybe it's not strange where they are. And I would bring that up as a defense attorney.
All right, so it's going to be interesting to see what happens with this trial. Again, once Law and Crime can get a camera crew back in the courtroom, certainly we will go live with that trial. Now, in the meantime, please join us. We're going to take a very short break, but we're going to be back and watching more testimony from the victim in this case. Emotional distress. Now you see she seems devastated on the stand, but let me ask my defense attorney, public defender, Brian, what do you make a testimony when you have a witness who's giving all the information, how bad it is, but then they're also breaking down, crying, and upset?
So it's not good. That's the first reaction. And what you've got to do is you've got to try to think quickly on your feet and try to parse. There's a difference between what occurred on that day and how she is recounting it. Being on the stand is stressful. Talking about what happened in the past, how it might have felt. She might be crying because she's nervous, because she's worried, because she's scared. But the question before the jury is, how did she feel at that time? And did she feel emotional distress during the period in which she has occurred, or sorry, serious emotional distress during the period in which she said these acts occurred? And did she feel that herself or her family were threatened?
So let me quickly ask you about the inappropriate acts. Are they just inappropriate? She said he's gotten multiple letters of reprimand that he has given her because she has not been positively responding to him and the personal efforts that he's making. Certainly that's inappropriate. Does that rise to the level of causing serious emotional distress and meeting the charge of stalking?
I think it does. And again, I'm going to play both sides of the fence. As a prosecutor, you're saying, absolutely. This is behavior that any reasonable person would know that you should not do, that this is not okay. Reciting where your mother lives, your brother lives, your sister lives, I don't care where you work, this is far beyond. And if someone told you this in the manner in which this occurred, and of course considering everything that happened, that is stalking by the statute. For the defense attorney, you've got to put it in a different light and say, no, this is how they communicate, this is what's going on. I'm not sure if they're raising it, but this sounds like someone who doesn't fully understand how to interact with individuals. I might even bring up the idea that maybe he has Asperger's, maybe he has some sort of development delay that doesn't allow him to interact with people the way that we do. And that's an angle I might explore.
Okay, so I want you to continue to watch because we are going to continue to cover that testimony. I am signing off for the day. Have a great weekend. Brian is going to stay with you, and I'm very excited that Linda Kinney-Bodden is going to be your next host to continue covering this trial, gavel to gavel.